welcome to Legal Insights, Solape Adesuyi. Okay, today we're continuing on our topic on estate planning. We've looked at what estate planning is. We've also discussed why you need to plan the estate. And today we're going to be looking at the different methods and tools that can be used for estate planning. Some of them are very common. We're familiar with the traditional methods include the wills or the codicil, includes what you call a deed of gift, or making use of foundations that we know of. So let me just go over these points quickly so you understand the basics of how to plan your estate. So first I'll start with a very common one that we know, which is writing of wills. Although it is common, I know that we seldom do it, sometimes for fear, but we have seen that beyond the fact that someone is dying, you're seeing the benefits of being able to plan your estate, because it's a superpower that you have to control what is happening even after your demise. And I think that is one thing everybody wants to take advantage of. So critically, when you write a will, it's important to understand that you need a lawyer, a legal practitioner or attorney to help you in writing your will. But it's important you understand first and foremost that a will must be voluntary. It must be voluntarily made. Therefore, it means that when someone is on a sick bed, you cannot then quickly say, okay, he wants to write a will on a sick bed. It will no longer be regarded as voluntary because there will be so many influences. And in fact, at that time, there's what we call the testamentary capacity of the testator or the person who is writing the will. You want to look at, does the person, that speaks to the question of the capacity of that person to write a will as at the time that it was written. It means that when a person is ill or has any mental condition, then that limits his capacity to make his decision, then you cannot say that that will was voluntarily written. Hence, it is important that in writing a will, you must do it at a time when you're sure that you have no medical issues that goes to the capacity of your decision making, no mental issues that affect the capacity of the testator to take a decision as to how he wants his estate to be managed after his demise. So voluntary, the capacity of the testator to write a will in a voluntary manner is critical to the validity of that will. Another thing to note about will is that it has to be written. It cannot be oral. I have had people ask me if you can do video and do oral. In Nigerian crime, I think it's critical. It must be written. You can choose to say you want to put it also on video, but critically, it must be written. So your will must be in writing. It must be signed by the testator, and it must be witnessed. So the testator must sign in the presence of two witnesses. And it's important to understand that a witness cannot be a beneficiary in a will. And so it means that when you're writing a will, the way you want your estate to be handled after your demise, it's important that you get at least two people who will be witnesses to this will. And so they are not going to benefit from it. They are only going to say, we're confirming that when you wrote this will, you were of a good testamentary capacity, you were in your right mind, you knew what you were doing, you were not under undue influence and all that. That's their function. They are witnesses to the fact that you wrote that will on your own voluntarily. So, and like I mentioned, your witness cannot be beneficiaries. Important to also state that will would have to be lodged in the court, or your lawyer can have copies of it to hold on your behalf, and then the necessary, once it is lodged in the court at the demise or at the event of your demise, then an application is made to the court for the will to be read to the members of the family and those who are beneficiaries of the will. A codicil. So let me also say that when you see the word codicil, a codicil is a document that is used to add to a will. So if someone writes a will today and is still alive in 10 years' time, in 20 years' time, and has acquired other assets, what it does is you just need to get to your lawyer, do an additional document that adds those assets or removes or do any adjustments to a will that is already written. You use the tool of a codicil. And you need a lawyer to help you do that. Again, another method you can use is a deed of gift. So I've had clients ask me, okay, what if I don't want to do a will? I want to give out my assets to my children or to people while I'm alive. So you can do that with the tool of a deed of gift. So you do a deed, which is also a legal document that the lawyer assists you with to give this asset to beneficiaries whilst you're still alive. And all they need to do is a registrable document, so they need to also register it by having it a stamp duty on it, and that would suffice to transfer the property to the people. Of course, if you do that in your lifetime, whilst you're still alive, there will still be other assets that you require to take care of yourself or to enjoy whilst you're waiting. So perhaps there will still be a document that will require to say, when I eventually pass on, the residue of my assets should be handled this way, and that way. Okay. Another thing that you can do if you want to plan your estate is also the use of foundations. So for those, like I mentioned in my earlier video, that depending on your goal, if your goal is not just to enrich your family members, your goal is also to be able to do something for the general public, then you want to begin to look at how you go about it by setting up a foundation. Foundation is a legal entity that you create, and creating a board of trustees who handle the foundation. The board of trustees then becomes the incorporated entity that manages that foundation. So you invest and put in your assets in that foundation to distribute on your behalf for the purpose of any common good or any good you want to do to the public. So a foundation actually can be a tool for your estate planning. Quite a number of people do that. So we have Rockefeller Foundation. We have so many foundations, people who are no longer existing, but their foundations still alive to perpetuate their interest. Okay, so we're going to be looking at other points, more common modern approaches to estate planning in our next edition. I look forward to sharing this time with you. Thank you.